Great trial lawyers are made, not born. Welcome to Verdict Academy, preserving trial wisdom for trial lawyers. Join host Kevin Morrison, trial attorney in San Francisco, as he recreates those invaluable hallway conversations that remote work has made rare. Candid insights and hard-won lessons from America's most accomplished trial lawyers. Produced and powered by LawPods.
Okay, welcome everybody to Verdict Academy. On this episode, I am beyond honored and pleased to have James Bostwick as our guest. Jim Bostwick is a legend with Bostwick and Associates. He is a member of the Inner Circle of Advocates. That's an invitation-only group of the top 100 plaintiff trial lawyers in the country. It's quite an honor. He is also a member of the International Academy of Trial Lawyers. That is also an invitation-only organization of the top 500 plaintiff and defense trial attorneys in the country. And not only is Jim a member of the organization, he's been a leader. He was president of the organization. He's a member of ABOTA, American Board of Trial Advocates, also an invitation-only group of the best trial attorneys in the country, again, plaintiff and defense. He is in the Law Dragon 500 Hall of Fame. He's been practicing 40 years at the highest level, and he is an author of a book titled Acts of Omission. It's about a young lawyer who takes on a legendary trial attorney in San Francisco in a malpractice case and wins a verdict. And I think it may be based on the truth, and Jim can illuminate that to us during their conversation. That book was nominated, as I understand it, for the Harper Lee Prize for Legal Fiction in 2020. So it's considered extremely well written, and I encourage you all to take a look at that as well. So Jim Bostwick, welcome to Verdict Academy, my friend.
Hi, Kevin. Thank you very much for asking me to be on. I appreciate it.
It's my honor. I know in your 40-year career, you've got wonderful 8-figure verdicts, more than it's too many to talk about. But you've done prox liability, you've done slip and fall, you've done all sorts of personal injury cases. You had a tremendous TBI verdict in a car crash case not long ago. But I also know that you have a particular affinity for medical malpractice, and you have a real history in medicine. My understanding is you got some blood in the medical field. Jim, you want to tell us a little bit about your background and what your folks did and how you got into law?
Sure. It is true that I mostly now do medical malpractice, and I got into it because I loved medicine. My father was a doctor, my mother was a nurse, and I thought I wanted to be a doctor my whole life growing up. Went to college as a pre-med till chemistry did me in. And
the old organic chemistry that winnows out the med students from the non-med students.
I could do the physiology and all the rest of it, but the organic chemistry, I don't know. So I didn't. At the end, I said, well, maybe I don't want to go to medical school. And on a lark, a friend of mine was taking the LSAT, and I didn't know what a trial lawyer was, but I did score well. So I went to Hastings back in the day. And you say 40 years, but I'm not going to tell you how many years, but it's a bit more than 40 that I've been doing this. I started with a very, very famous office as a law clerk back in the 60s.
Bruce Walkup, a legend.
Walkup.
Yeah.
Legend. One of the founders of the Inner Circle. Unbelievable trial lawyer. First $1 million verdict in the history of the country. Just a wonderful mentor. And so I had 10 years there. I went off with a couple other guys to start our own practice. But in the process, of course, in those days, as a law clerk, I'd had about 100 cases, and I'd run down the hallway to find Paul Melodia or somebody to go take a deposition for me. because I couldn't, because I wasn't a lawyer yet. But I was turning over cases, and we did all kinds of stuff. And I've tried all different kinds of cases. Many in those days we tried lots of stuff, but I kept getting sucked into the medical stuff because I have an affinity for it. I understand the medicine, I can speak the lingo, and everybody started sending me their malpractice cases in the firm and outside the firm, and that just became my thing. In fact, it's evolved to the point now where I'm pretty much only doing things like birth injury cases and things like that. I do other kinds of malpractice cases as well, but very selectively. And it's just something that I love. It's something that I understand, something that I enjoy, and everything we do. Luckily, we're also lucky on the plaintiff side because we get to help people, but particularly when they've been failed by the medical system. There's just something that really feels good about helping those families. And you can't fix them, unfortunately, but you can really make a difference in their lives.
You sure can. And all the money you've garnered on behalf of your clients has helped them live better lives. So that's a wonderful gift that you have.
I've enjoyed using it.
Yeah.
I have very much.
Well, there's a special place in heaven for medical malpractice plaintiff attorneys, I think, because the deck is stacked so against you walking in. I mean, everybody thinks that doctors walk on water and they don't make mistakes. And if they do, you know what? At least they're in there trying to make the person well, right? I mean, how bad can it be?
Yeah, they mean well. They're human. They make mistakes. But the trouble is the jurors all need doctors. We all need doctors in hospitals, and we don't want to think they do things wrong.
Nope. Gotta
Every
trust them.
juror starts out with a subconscious mindset of, no, they didn't do anything wrong. I don't want to believe they did anything wrong.
Yeah.
And that's what you have to overcome in those cases. That's why not only are the most expensive, the most risky, most complicated. Product cases can get damn complicated too, of course, but
Sure.
they're a challenge, and I love it.
They are a challenge. And experts are so important. And we're going to get into basically the format of the show is, again, our audience tends to be younger trial attorneys who want to learn from the masters. The days of bumping into folks in the water cooler are disappeared or gone because of work from home situations. So we want to give tips to younger attorneys from the masters like yourself. And I think one of the issues we want to talk about is expert selection. And is there any more critical practice area in selecting experts than the medical malpractice? Since I'm guessing, Jim, I don't have the brains or courage to do med mal, but I'm guessing it can be a challenge to find a physician who is willing to testify against a brother physician. Is that in your experience?
Well, yes, it is a challenge. It isn't as much a challenge as you would think because there's some out there that are willing to say damn near anything. Those are not the ones you want. Yeah, the first rule is pick an expert who doesn't want to testify, who doesn't usually testify, who when they do testifies typically for the defense, but thinks that this case is just so awful that they have to stand up and be counted, and that's what you want. Of course, when you're talking about this, you're talking about the first rule of medical malpractice, which is case selection, case selection, case selection. It's true in all the different fields that we practice in as PI lawyers, but it is particularly true, of course, in medical malpractice. And you want, of course, highly qualified people. You want more than one in very important areas. I try to have at least two, maybe more. Why? Well, because you hear things differently from different experts. You get a better and a more nuanced perspective. You also have a backup if the one you decide to use gets sick or gets hit by a truck or or gets cold feet, and that happens. Sometimes they just disappear on you. I've had that happen. And so I always have more than one. I try to find people that, really understand to find an expert in the start, the process. You have to know your case. You have to learn it. You have to know it really well. You have to know the facts. You have to understand the facts medically. And you have to challenge those experts you're talking to. You have to challenge them because that's how you find out if they're going to hold up. It's also how you find out if they're, if they really mean what they say or if there are holes in what they say. And that's when you find out how they're going to be on the stand.
And so as you approach expert disclosure, presumably the experts reviewed the materials you provided, and occasionally he or she may get cold feet, may think the case is not as advertised, or simply just says, you know what, I just not feel comfortable. Is that when you kind of meet that with them in person and kind of go over a direct, or if they're just not willing to go there, you just get rid of them? Because if they're going to be a little squishy going into a deposition, it's not going to probably not get better when they get cross-examined.
No, it's not. And once they're on the record, that's a problem. So yeah, I don't want to meet them just before the deposition. I want to get a good handle on them well in advance of that, and cross-examine them myself, and in a nice way, but really start saying, well, let me play devil's advocate with you about this doctor. It'll help me understand things better, and then kind of go at them a little bit and see how they handle it, see how they handle themselves, see how they, because the defense lawyer is going to be well prepared. They're damn good at what they do. They do it every day, and they've got their choice of experts. It's easy for them to find experts. I've had some of the most god-awful cases that you would just be shocked at what happened. Never had a case where the defense didn't have an expert say, oh, it's fine. I mean, they find ways to say it that doesn't sound
amputated the wrong leg, but that leg was not in good shape anyway, so
they were going to need to lose that one anyway. These people with these terrible diabetic problems, they're going to, it probably helped them not have to go through 2 surgeries.
There you go. We did him a favor.
Yeah, we did him a favor. Yeah, we saw that was kind of a good leg, and we did the other one at the same time.
Yeah,
it was a good thing for him.
Yeah. And how do you figure out, you're obviously extreme, knowledgeable medicine. You probably know as much medicine as the doctors you're suing.
You better when you're cross-examining them. I mean, at least in that area.
Yeah. How do you find them? Do you just know, you're so knowledgeable in the area, the top guy at UCLA, for example, or Stanford, or somewhere back east, or do you do research on journal? You find who wrote journal articles? What's your methodology to finding these experts?
All of the above. I have, back in the day, I could spend months looking for experts. I could tell a couple stories. I'll tell one, but nowadays we have things like the Expert Institute. And I don't like these expert finding groups. I've never used them because they get stables, and the defense lawyers love to find out they're signed up with some expert group. Typically that's just death. But the Expert Institute is totally different because they help you. They're your agent. They're like part of your firm helping you look for the expert. They give you some names, you talk to them. And then you decide if you want to hire them. And that's a whole different approach to finding experts. That has helped me immensely. But still, you got to talk to a lot of different people. You got to do a lot of research. You talk to your friends that do the same kind of thing. Who do you know? You find the best. You talk to them. I mean, I had one case, literally, where I think I talked to every good top pediatric surgeon in the country. All the heads of universities. Everybody said, this is a known risk. It's a known risk, I mean, 3-day-old baby, it's a known risk that the Verus needle was going to get in when they're insufflating to do a laparoscopy. But I kept saying, wait, if it's a known, has it ever happened to you? Well, no. Has it ever happened to any of your colleagues that you respect? Well, no. Well, it's a known risk to blow a stop sign, but that doesn't make it acceptable. So you have to know your case, and you have to start going after it a little. I finally found one expert in the country, I felt like, and it was not an acceptable risk. It was a known but not an acceptable risk. That case settled for many, many, many millions of dollars. But that's how it works. Now, it's not always like that, of course, but
I love that known risk versus acceptable risk. I learned that from you and reading some stuff from you. I think that is such a wise and understandable for a jury panel to get it. There are known risks. When you get in a car, you get in a bicycle, you could get hit and killed, but it's not acceptable to be blowing stop signs and being distracted driving. And so that's different. So I love that analogy. I love that, Jim.
and that feeds into the themes that we develop. We should be thinking all the way through our case from day one. How does this best present to a jury? How can we simplify it? How do we keep it? The defense loves to get it complicated. They love smoke and mirrors. They love to get the jury confused. That's very good defense work, of course, especially in a medical malpractice case.
Yeah, a confused jury is a defense verdict. I say it all the time. A confused jury is a defense verdict. Yep.
Well, yeah, 80-90% of them are all defense verdicts. And it's because juries do get confused. And they're dealing in an area that they're not experts in. But if you keep it simple, if you case selecting, pick the right case, and you develop a theme, and you keep it to something that you can present to a jury in 15 or 20 minutes. They can't focus for very long.
Well, attention spans are shorter and shorter because of phones and computers and distractions. 100%. How do you select an effective theme, Jim?
Well, that's not easy. That's not easy because you got to know your case really well. I have used focus groups, and I have tried different themes on them, and I've listened to them talk about things that resonate with them. I have done that many times. I talk to lots of friends who do this, and it's invaluable to have other lawyers that do the same kind of work that you can kick the case around with and get their ideas. But most importantly, I talk to lay people. Yeah, not just the family at dinner. They get real tired of that. But I talk to people that I meet and ask them if they mind if I tell them about a case, and I see what they're responding to. I see when I'm talking to them what comes through and what doesn't, even when it helps me think it through. And that's how you start developing your themes. Just you mentioned that case with the lady with a mild traumatic brain injury. I don't know why they call it anything mild. If you have a traumatic brain injury, you got a brain injury. There's nothing mild about that. But she had an IQ of 160, and she was brilliant, and she was smarter than everyone in the courtroom in the trial. She never missed a question when she was on the stand. The judge, who was a Harvard-trained judge, thought she was smarter than he was. That's a problem.
Yeah.
But she had an executive function problem. She had an executive traumatic brain injury, and she could not do more than one thing at a time. She could not multitask. She could answer any question you wanted, but if she was cooking and somebody talked to her, she'd burn the dinner.
Mm-hmm.
She couldn't drive with a radio on, or she'd blow a stop sign.
Wow.
And so my theme became, and everybody I questioned, and every expert and everybody in the case is, can you appear to be perfectly normal but still have a major problem that affects your ability to function in life. And then I used, and they all agreed with it. They had to. It was true. And then I started with the jury in selection talking about that. And I had people in the family talk about how smart she was. But the problems they observed where they're trying to just do this thing or that thing. And then selection of an expert. I selected an expert, fabulous neurosurgeon that happened to have had a brain injury of his own. But he was lucky. You have about a year to recover. He recovered in about 6 months, but he told the jury what it was like for that 6 months.
That's great.
Mesmerized.
Yeah.
It kind of, that's all the things put together,
Yeah.
Anyway, that theme really helped in that case.
Yeah. And you interweave your theme through crosses and directs and closing?
Oh, yeah.
Yeah.
Yeah. And you keep coming back to it. You keep using it. It becomes a central cohesive bonding mechanism.
Right.
I can't. I think the people that, I did it for years. Many lawyers do it. We get so involved in the facts of our case because that's how we think, and we get we have all these little battles, and we get mesmerized by the trees and miss the forest.
That's right.
The big picture is so important to remember and come back to.
Yep. Yeah, someone told me once themes are important because you want something, when that juror goes home and talks to his roommate or his spouse or whatever, what's this case about? And they're not supposed to talk about the case is about, but they could say, this is about a lady who appears normal but isn't. That's what you want them to talk about, right?
Yeah, exactly. And then their friends are going to say, well, why, if she appears normal, why, how isn't she normal? And then oh, wow, that's horrible.
Mm-hmm.
Examples like, you mean she can't have the radio on when she drives? Oh my,
Yep.
That sticks in your.
Yeah, because we all have that experience, right? We know what that's like, and we can easily relate to that.
Yeah, we've all had moments of losing focus, and we've had moments of distraction, and so we understand if your life is that way. Wow.
Yeah.
What a major problem. And then she's a major executive recruiter, and she can't do it anymore. That's really important.
Absolutely, and you got a wonderful verdict for her, and you helped her get better. So that's fantastic.
Well, I was lucky because we had $6 million offer on the case, which was a lot to turn down, and she was brave.
That's real money, and sometimes
you want
to take the chips off the table.
That's right. And that was nerve-wracking.
Yeah.
She was a brave person, and she agreed with me. That wasn't enough. And by God, it wasn't. But I tell you what, I had her sign about a 4-page letter.
Yeah, you got to. For sure. Yeah. So last topic I'd like to get into, I know you're passionate about like a jury selection and opening statement. What tips do you want to give to younger lawyers about the importance of jury selection and then an opening statement? Do you view those as kind of closely tied, jury selection and opening, Jim?
Very much. You're talking about the same things. And what is the most important thing you don't want to ever not have talked about? It is the bad things in your case. Every case has bad, negative.
The things that hurt your case.
The things that hurt your case. The things we all like to stay away from. The things we want to put our head in the sand about. The natural things that you don't ever want to hear the defense lawyer stands up and say, a very important thing that Mr. Bostwick didn't tell you about. And then, lay something on and the jury looks at you like, you hid that from us? And that should be You should be talking about it with the jury when you're doing voir dire. You're getting to know them. You're getting their feelings about things. You want to get them to open up. But what do you use to get them to open up? As much as the good things, the bad things.
That's right.
The things in your case, we're gonna, there'll be things like this, and you have a way to present it, carefully thought out, that doesn't, make it sound like, well, your case is worthless. I mean, but to say that things can be seen from multiple sides, and you will hear, I mean, you will hear my client had a serious drug problem, and the defense is going to talk a lot about that. And some people may just say, "Oh, I've had family problems. I have had situations. I just couldn't deal with that." And a lot of us have been there. We just need to hear about that.
Yeah.
You need to get people talking. And they're even more nervous than you are. And I'm always really nervous because picking a jury to me is Russian roulette.
Mm-hmm.
You don't
Mm-hmm.
know what the hell they're really thinking.
Mm-hmm.
But if you get them talking, then you can start getting a feeling for it. And I think it's so important. And then you do the same thing at opening. You've got to talk about those things. And then guess what? When you put your expert or your witness on the stand, what do you want to spend a lot of time on? When the defense lawyer stands up, I want them to not have anything left to talk about. I want to have covered it all on direct.
Right.
And I will have done it in opening statement too. But you got to find a way to do it fast. Because you can't spend too long about it. Anyway, but just get the people on the jury talking.
Mm-hmm.
Get them saying a little bit about how they feel. It's hard to do.
Yeah. Credibility is so important. As I tell some of my law students I teach, there's three things that are important in trial: credibility, and then credibility. And
oh boy.
I mean, you have to be viewed as the truth teller in that courtroom. They got to trust you, right?
Got to be a storyteller, and it's got to be a truth teller.
Yeah.
Yeah.
100%.
You got to tell a story they want to listen to and want to hear about and want to hear the end of. And you cannot lose credibility.
Yeah. How about money? In a birth injury case, you're going to have a life care plan that's going to be 8 figures typically, right? And so you're going to ask a jury for 50 million, 75 million and up in some of your cases. Do you get that out in jury selection? Hey, you're at the end of
Absolutely.
Tell me about why.
Well, because there are people on there that are just going to be so turned off at the concept right away, and you need to know about those people, and you can say it in a way. You can talk about, this is a young person, that has 60 years of life ahead of them, needing 24-hour care. Guess what? That's expensive, and the numbers are shocking. The numbers are shocking. You can talk that way. The numbers are shocking. And, all I need to know is I don't need you to, don't you need you to decide anything right now. I just need to know is if we prove to you, and that's our job. And I talk about that. It's our job, and if we prove to you that this case has, the actual needs are, $65 million or $70 million, or maybe give them a range. Maybe there's options, you don't get too specific. Some judges are tough on that. Some judges aren't.
Mm-hmm.
You got to find out ahead of time whether you're going to get in trouble.
Right.
But you have to find ways of talking about large sums of money. And I think most people nowadays think that you have to ground them in, they have to give them a number.
Yeah.
There's a lot of lawyers that feel like not giving them a number, at least by the end, is a mistake.
Yeah. I always felt that a jury assumes that the lawyer knows what the case is worth, right? So why the heck isn't he telling me what the case is worth? He's got to have experience. He does this for a living. I don't know what the case is worth, but he must know.
I've always found it helpful to talk about. It's more an argument. You can't do it in voir dire, but talk about how society values things, like how much money we would not think about not spending millions and millions and millions of dollars to save a kid. Think of some
Yeah.
situation, save a kid,
Right.
and to help the kid that's in trouble or something like that. You can
Yeah.
think of lots. The pilot,
Yep.
the pilot put the plane in the ocean. You bail
Yeah.
out. Don't try to land the damn thing.
That's right.
We don't care about the multi-million-dollar plane. We care about you.
That's right.
That's our society, right?
That's what we value.
That's jurors understand that stuff, and they think, oh, well, yeah,
Yeah.
yeah, we do value life. We do value things like that. I think that stuff helps.
Yeah. Well, as we anticipated, Jim, the 30 minutes flew by, but I don't want to close with an opportunity to talk about your book because it's so fascinating, Acts of Omission. It's based on a real trial that you handled. Do you want to give our audience just a few minutes about the trial you handled against a legend and about the book and where we can buy the book?
Yeah, you can buy the book on Amazon,
Okay.
and it's actually a very, very, very popular book on Audible,
Okay.
and it's got about a couple thousand 4 and 5 ratings.
Mm-hmm.
He did a really good job. He was an actor. He gave people's voices. I don't usually listen to books. I read them, and that was the first one I ever listened to, and it was a whole different thing than writing it or reading it myself. But uh, it's actually recommended reading in several law schools because one of the things I wanted to do was actually have a book that was somewhat realistic about what happens in the law, how lawyers deal with their clients, what happens in court, how lawyers deal with each other, how a lawsuit is developed. It's a novel, so it isn't dry and boring like the law can be, but I wanted it to be realistic, and that's one of the things that I've heard from lots of my friends that are trial lawyers that have read it. Is that's what they liked, that it resonated, it was real. But it was a back in the day. Most of the people that are listening are younger people, so they won't even know the name of this person that I sued. But he was a legend, not just in San Francisco and California and in the world. He was probably one of the best known trial lawyers in.
King of Torts.
He's the king of torts, Melvin Belli, and nobody will say, "Who's that?" uh, and that shows how long ago it was. But he invented demonstrative evidence. He was brilliant. He did it a little too long, maybe. People could say the same about me, perhaps, but he he messed up with a kid. He said he didn't, and we had a 7, 8, 9 week trial in San Francisco, and it got a lot of publicity when we finished it. And the book is loosely based on that, which is kind of a fun aspect of it. But it is a novel.
Yeah. Well, I put the order into my. I'm not a big Amazon guy for personal reasons, but I put the order in at my local bookstore, and I'm gonna pick it up next week. And I urge our audience to too. And I want to thank you, Jim. Thanks for being a guest. Thanks for everything you've done in your career, helping the trial bar, helping the academy the way you've done, and educating our next generation of trial attorneys. As you know, jury trial is a precious constitutional right. We can't lose it. We lose the jury trial, we're going to lose our democracy. So thank you for all of your efforts in that regard.
Thank you. Thank you very much for having me. It's been fun.
It has been fun. Could do it for 2 more hours, but
It's a good thing that you limited it to 30 minutes because we
yeah,
keep going.
we chat all day long. Anyway,
Yeah.
thanks a lot, Jim.
Thank you for listening to Verdict Academy. If today's insights resonated with you, please subscribe and share with colleagues. In a world where we see each other less, learning from experienced trial lawyers matters now more than ever. Join us next time. Produced and powered by Law Pods.